Okay, I think we should probably begin. If there's anyone who probably arrives late to this webinar, the good thing is that it will be recorded, so they can watch a copy of it after the presentation. But to those of you who have joined, good morning and welcome to today's webinar. Thank you for joining us on our session on employment law considerations under COVID-19. So before we begin, I'd just like to run through a few housekeeping matters which will hopefully enhance this webinar experience for each of you. So as participants, you're all automatically muted and any kind of chat functionality has been disabled. So should you have any questions during the webinar, please make use of the Q&A tab, which is just right at the bottom of the screen. Your questions will be submitted to me as the facilitator, and I will select an appropriate time during the panel discussion to ask that question, and hopefully one of our panelists will be able to respond to it. So please note that we will not be providing any written responses to all of these questions. So the presentation is fully oral. And you know, this, as I've mentioned, this webinar is being recorded. So a copy of this will be available on our website later this afternoon. So today, I'd just like to introduce the panelists to all of you. We're joined by 3 senior associates in our employment and benefits practice. That is Lenja Dahms-Jansen, Yeleni Bruinders, who are both from the Sandton office, and Chloe Loubser, who's joining us from our Cape Town office. So the first question, and I'm going to direct the question to Chloe, who's one of our panelists. So I'm going to start off with a topic which I'm sure has been front of mind for many businesses during the last 8 months since the COVID-19 lockdown has begun. And that question is something that has been receiving a lot of airtime on social media and also the news lately. So in relation to the TERS benefit, Chloe, could you please explain what the TERS benefit first of all is, and provide us with any updates on the status of the benefits, and briefly explain its history to us?
Sure, thanks Linda, and good morning everyone. So the COVID-19 TERS benefit was established at the beginning of lockdown in terms of the COVID-19 Temporary Employer-Employee Relief Scheme Directive that was issued by the Minister of Employment and Labour on the 25th of March. The scheme was established as some relief for employers and as a benefit for employees whose employers were unable to pay them during the lockdown. The TERS benefits are administered and paid by the Unemployment Insurance Fund, but they're de-linked from the UIF benefits. So this means that the ordinary requirement that an employee needs to have UIF credits in order to claim the benefit does not apply. There have been quite a number of amendments to the directive over time, many of which arose as issues were being picked up in practice as it became live and employers started applying for the benefit. For example, in the beginning, the benefit was only available to contributors. And what this meant was that it was only employees who, together with their employers, were actually making that monthly UIF contribution to the fund who could claim the TERS benefit. But what government then realized was that there are actually a number of employers who hadn't registered their employees with the fund or weren't actually making these monthly contributions, and they were being left out. So the directive was then amended to allow all workers to benefit from the fund. Another change was that initially only employers were able to claim the benefits on behalf of their employees. But again, government then realized that there were many employers who were failing to apply for the benefit on behalf of their employees to the detriment of these employees. So there was a further amendment which then allowed employees in certain circumstances where they were eligible for the benefit to then claim on their own behalf. So initially, this benefit was only available for 3 months until the end of June. and an employer was able to claim benefits on behalf of its employees where its operations were closed, either partially or in full, as a direct result of the COVID-19 pandemic. The benefit was then payable to employees who had lost income as a result of their employer's closure, and there was also a benefit if the employer required employees to take annual leave during the lockdown. The directive also made provision for illness benefits in the event where employees had to be placed on quarantine. And the process was that the employer would contact the fund and then have to enter into a memorandum of agreement with the fund, in which the employer, or in some cases a bargaining council, would agree to receive the benefits from the UIF and then to distribute those benefits to its employees. So as I said, the directive initially came to an end at the end of June, and it wasn't initially extended. Only on the 21st of July did the government then announce that the TERS benefits would be extended until the 15th of August. And a new directive was then published, which you had to read together with the old direction to govern the benefits from 1 July. So while the initial directive was quite broad and it applied to all employees who had lost income if their employer's business was closed, the benefits from 1 July were a bit more prescriptive, and they only applied to certain categories of employees. And those three categories were employees whose employers were not permitted to commence operations, either partially in full because of the regulations, who were unable to implement special measures in respect of vulnerable employees or to make alternative arrangements for these employees to work from home, or employees whose employers were unable to make use of the employee's services due to operational requirements, and in particular, this need to limit the number of workers at the workplace through staggering, rostering, and shift systems and so forth. So essentially, from 1 July, the benefits were only available to these certain categories of employees. Where things currently stand, so the benefits were initially extended until 15 August. Then on 7 September, there was a further extension, and this time the wording in the directive was actually changed. So it now reads that the benefits are available for the duration of the national disaster, or until the directive itself is withdrawn by the minister. So there's been a lot of debate recently about whether UIF applications will still be allowed, because essentially the UIF closed all applications for the period until 15 September on 30 October. So no further applications have been permitted after 30 October. Technically, we are still in a state of disaster, and it's just been extended again until the 15th of December, and there's been no formal withdrawal of the directive. So technically, the benefits should still be applicable. But you may have heard in the media last week that there was a unilateral decision by the National Coronavirus Command Council to say that the benefits would no longer be applicable after 15 September. This created quite a lot of uproar amongst social partners, and you would have heard in the President's address on Wednesday night that a decision has now been taken to extend the benefits until 15 October. We understand that there are still some discussions with social partners about a possible further extension, and they're also looking at alternative options that may be available for employers who are still in distress. But unfortunately, at this point, it looks like 15 October is the cutoff. But what we must remember is that even when the benefits are no longer payable, it's important to keep in mind that there are still normal UIF benefits. And this is one of the biggest considerations that they've been bearing in mind when deciding whether to extend the benefits, is that the UIF needs to make sure that there are sufficient funds available to pay these other benefits. So for example, as an employer, if your employees are sick and they've run out of sick leave, they can claim illness benefits from the UIF. Or for example, if you've had to place employees on short time, even though you might not be able to claim from TERS, there are reduced working time benefits in the normal UIF category of benefits, which you may be able to claim for your employees. And obviously, in the unfortunate event that retrenchments are necessary, employers would be able to claim unemployment benefits. But bearing in mind that all of these benefits are subject to the requirement that employees will need to have credits available to them.
So, okay, thank you so much for that, Chloe. Just on the point of retrenchments, because you just mentioned that. I don't know, perhaps Yeleni can assist us with this point. So when an employer suffers financial distress as a result of the partial or complete closure of their business operations arising from the coronavirus, can they follow a different retrenchment process during the lockdown or national disaster?
Thank you, Linda. In short, the same procedures apply in terms of our law. There isn't a temporary process regarding retrenchment during the national disaster. But I thought it would be useful to just go through briefly a presentation on what are the alternatives that you as an employer can consider if your employee is, if your company is struggling and you're looking at cost-cutting measures. And if you are unable to find these sorts of measures, short of dismissal, what is the process in terms of retrenchments? So can you see my screen? I just want to make sure that it is. Okay, great. So I'm sure, everybody by now is aware of the fact that we have had an overwhelming effect from COVID-19. The financial implications have been huge. The South African economy shed 2.2 million jobs in the second quarter of 2020, and these statistics are quite frightening. So it's no surprise that some companies are looking at ways to try and cut costs and immediately looking at retrenchment as a way to survive. Now, if you are looking at retrenchments, it's important to know that there's a specific procedure in our law that you need to follow in order to make sure that you are complying with the law. That procedure can be found in Section 189 of the Labour Relations Act. But it's important that you are aware that our law also requires retrenchments to be a last resort. So you need to try and explore all alternatives short of dismissal before taking a decision to retrench. And this has also been echoed by our governments who have said that it's really important to try and, accept and acknowledge that this is something that has negative effects on our business, but it's also something that's temporary. It's going to pass, and we must try and not take drastic permanent measures when there are temporary measures that we can potentially implement and therefore assist in cutting costs, but also ensuring that you maintain, your employees in your business. So how can you potentially cut costs without going through a retrenchment process? There are a few measures that you can potentially look at implementing, and what you would need to do is try and discuss with your employees whether they would be amenable to these kinds of measures. So some of the measures that you can look at implementing are requiring employees to take annual leave, requiring employees to take unpaid leave, or looking at work short time. So what this means is that you would reduce the hours that your employees work within a week, and then you would also reduce the salary in conjunction to the amount of time that they will be, less that they'll be working. Then you also can potentially reduce salary without reducing the amount of hours that they work, or potentially look at temporary layoffs. This is essentially suspending the employment contract so that you aren't required to pay them for a specific period, but they remain on your payroll and they essentially still have job security down the line. Before you take these kind of measures, it's important that you ensure that you are not subject to a collective agreement, which may prescribe certain requirements if you are looking to implement short time or regulate these kinds of terms and conditions. If you do not have these kinds of agreements in place, then you can contact your employees directly and try and discuss with them and negotiate how you can come up with an agreement that will benefit the employer, but in the same time, something that an employee will be willing to accept on a temporary basis. Should you be able to agree to these kinds of amendments, it's important that you record these in writing so that you've got proof of this agreement should any dispute arise. So what happens if no agreement can be reached? What happens if your employees flat out refuse? Can you go ahead and implement these kinds of measures without the consent? When it comes to accumulated annual leave, you can. This is something that's up to the discretion of the employer. And if your operations are temporarily shut down or they aren't operating at maximum capacity, you can then request your employees to take annual leave. But any of the other measures would be amending the terms and conditions of their employment. And you are not allowed to do this without your employees' consent. So, some companies look at the risks and try and weigh up whether they are in such a bad financial situation that they would rather take a risk and implement these kinds of measures without consent. Of course, this is not in line with the law, but it's a business decision that you need to weigh up. Of course, there are risks with this approach. A unilateral change in terms and conditions of employment amounts to a breach of contract. So your employees will therefore be able to use contractual remedies to enforce these terms. So either they can apply for specific performance or damages, and you would then obviously be liable to pay them for breaching these contractual terms. It's important to note that, I think when you're looking at how you can potentially justify these kinds of situations, it's important to kind of acknowledge that this is a pandemic. And I think that sometimes if you can try and explain to your employees the situation that the company is facing and that you really are trying to avoid them being retrenched and you're looking at conditions or measures that can potentially allow them to stay at the business, this may be a way that you can try and potentially get them to agree. But of course, if you are going to take the risk, you need to be aware of the financial consequences, and you need to make sure that if you are going to do that, you adopt these kind of measures consistently across the board. Now, if you can't get any kind of agreement and you aren't going to take the risk and take unlawful action, you then are left with having to follow a retrenchment process. And this is your last resort. You've looked at alternative measures and there's nothing else that you can do in the circumstances. Now, our law requires that you follow a fair procedure. So you need to engage in a meaningful joint consensus seeking process with your employees. What this means is that you cannot take a decision to retrench your employees and implement the retrenchment without having consulted with your employees on a number of factors with regards to this retrenchment. You're not required to reach consensus with your employees, but you certainly need to try and attempt to get there. Obviously, you need to ensure that you can justify that you have a proper operational requirement, and this would be either economical, structural, or technological. And if you've got one of these justifications, then generally you will be, within your right to enter into some kind of retrenchment process. With COVID, it would obviously be a justifiable reason because you're financially unable to sustain your business if you don't look at these sorts of measures. The measures that I've discussed with you previously can also be viewed as alternative measures within the retrenchment process. Now, sometimes employers don't want to have to first try and discuss with their employees an alternative, and they'd rather jump straight into a retrenchment process and deal with these measures as alternatives, and that's absolutely fine. But if you do not want to contemplate retrenchments and you don't want to alarm your employees and go through this formal process, if you believe that you will be able to potentially agree with your employees, then you can try and agree with them on this basis before you start a retrenchment process. And as Chloe said, there are UIF benefits that you can potentially claim while implementing some of these alternatives so that your employees are not without any pay during that period. What our law requires is that you need to commence this process with a Section 189.3 letter. What this letter requires is for you to include a number of topics of discussion that you need to discuss with your employees. This is the reason for the potential retrenchments, the alternatives that you consider, the number of employees who will be likely to be affected and the job categories in which they are in, the proposed method for selecting who will be affected, the timing of when potential dismissals will occur, the severance pay proposed. In terms of our law, you are required to offer at least 1 week per completed year of service, and then looking at any assistance that you will offer your employees. So whether that be assisting with UIF benefits, allowing them time off to look for other jobs, or potentially trying to provide them with certificates and references and the like so that they can look for a job far more easier. I just wanted to touch on the selection criteria because I think this is important for you to know who are you going to look at if you're looking to retrench. The selection criteria needs to be objective and fair, and you need to ensure that you at least attempt to reach agreement with your employees. Generally, people like to adopt LIFO, which is last in, first out. You're looking at the length of service, and you can then keep your long-standing employees, safe. Other selection criteria can potentially be skills and qualifications, or if you're looking at specifically removing one job. So if you realize that one job with COVID has now had far less business and you aren't able to suitably maintain a level of work for that individual, and you can justify that that job will no longer be required going forward in the business, then your selection criteria will be whoever occupies that role. And just in terms of a brief step-by-step guide in terms of what you should do when you're starting the process, you'll first issue your Section 189.3 letter, and then you'll need to consult with your employees. Our law doesn't prescribe a number of consultations that are required, but you need to ensure that you have appropriately spoken to your employees and that you've dealt with all matters and your employees don't have any more questions for you. So your second step will be to have a consultation process where you discuss the operational requirements, the proposed alternatives, and the proposed selection criteria. If your employees have questions, you need to consider these questions and you need to explain why you do or don't accept some of the representations that they provide to you. If they need to have further considerations and discuss issues further, you'll then have a second consultation on those issues. You'll then discuss the next requirements, which will be proposed timing and proposed severance pay and proposed assistance. Once you are satisfied that you've discussed all of these topics at length and you and your employees have attempted to reach consensus, you can then issue a notice of termination because you've satisfied that you've gone through the consultation process and there are no alternatives short of dismissal for you to implement. And finally, just looking at what are the do's and don'ts in these kinds of processes. You cannot make a decision to retrench without first completing a consultation process. I can't stress this point enough. You will be deemed to be following an unfair process if you don't allow your employees an opportunity to engage with you in this process. It's important that you keep minutes of every consultation so that you can ensure that your appropriate document and record exactly what has happened throughout the process. You need to provide your employees an opportunity to respond and make representations, which we've spoken about. Where you reject a representation, you need to explain why and provide a justifiable reason so that you can show that you have considered every representation that your employees make. And then finally, if your employees address any of their concerns to you in writing, it's important that you do respond in writing back to those employees. And finally, retrenchment is an uncomfortable topic. It's something that is a difficult process, but if you followed the correct consultation process and there are no alternatives short of dismissal and retrenchment cannot be avoided, then you can make a decision to retrench and be comfortable that you've complied with the law.
Okay, thank you so much, Yeleni. That was a very helpful presentation. So one of the biggest considerations for employers during this pandemic has been the health and safety of their employees. Lenja, could you please explain whether there are any particular health and safety requirements that apply to smaller businesses and whether the same requirements apply regardless of the size of the business?
Thanks, Linda, and good morning, everyone. So in short, yes, there are specific health and safety obligations, but they don't apply as extensively as they would to medium and large businesses. So what happened is that on the 1st of October, the Minister of Employment and Labour published a new consolidated COVID-19 direction on occupational health and safety in the workplace. And I'll refer to this as the direction as I speak. So the direction refers to and incorporates provisions of the Occupational Health and Safety Act, and it takes into account developments that have been communicated by the Department of Health insofar as new information about the coronavirus has come from sources like the World Health Organization. Most of the provisions in the direction apply to medium and large businesses, but there's a specific direction, Direction 12, which does impose certain obligations on small businesses and which must be complied with. So for purposes of the direction, a small business is understood to mean one where the employer has 10 employees or less. Where employers have 10 employees or less, they need to take the following measures to protect the health and safety of their employees. So firstly, they're required to develop a basic workplace plan for their employees' return to work. In preparing this plan, they need to take into account sort of the various categories of employees that work in the workplace. So, for example, they need to take into account those employees who, if any, can work remotely, so work from home and render services, if not from home, remotely. They need to consider the employees that they have who are over the age of 60, and they also need to consider those employees who have comorbidities, so who have pre-existing health conditions. People who are over the age of 60 or who have pre-existing health conditions are deemed to be at a higher risk of complications or death if they are infected with COVID-19. And so what the law requires is that additional measures should be taken by employers to protect these vulnerable employees' health and safety. Direction 12 also requires that employers arrange the workplace to ensure that their employees are at least 1.5 meters apart. And where this isn't possible, they must put in place physical barriers between the employees to prevent the possible transmission of the virus. So we'd all be familiar with the plexiglass that we've seen everywhere lately at workplaces. Small employers also need to ensure that employees who present with symptoms of the virus, so for example, a cough, a sore throat, shortness of breath, loss of taste or smell, and who may also have fever or body aches, are not permitted to work. Where an employee does show symptoms of virus, the employer needs to immediately contact the relevant provincial occupational health and safety inspectorate for instructions on how to handle the employee, and it needs to direct the employee to comply with those instructions that are issued by the provincial inspectorate. So a list of the provincial inspectorate's telephone numbers that small employers can contact is attached to the directive. And if there's a request for this, we can always circulate a copy of the directive after this presentation. It goes without saying at this stage that small employers, as with all employers, must provide cloth masks or require an employee to wear some form of cloth covering over their mouth and nose while they're at work. I think we all know that this is mandatory. Employers are also required to provide each employee with hand sanitizers, soaps and clean water to wash their hands, and disinfectants to affect their workstations. But they also need to ensure that all employees, while they are at work, wash with soap, sanitize their hands, and disinfect their workstations regularly. So it's not just about providing these items, you need to ensure that they actually are used by the employees. Finally, small employers must also take into account any other measures that could be required after they've conducted a risk assessment of their specific workplace, particularly where the public has access to the workplace. So what you do there is you look at the specific circumstances of your work environment and you decide what is unique to your work environment that you should be taking into account and implementing. So these could be considerations such as ways of minimizing the number of employees that need to be at the workplace at any one time, and also ways to screen employees, clients, contractors, and visitors at the workplace. Small employers must comply with the workplace plans that they put in place, and they should ensure that their employees are familiar with the plan so that they are aware of what is required of them, because there's also a duty on employees to adhere to the obligations that are imposed for them for health and safety. A copy of the workplace plan must also be made available to an inspector from the Department of Employment and Labour if it is requested. So yeah, Linda, that in short is the occupational health and safety for small employers.
Okay, thank you for that, Lenja. But I mean, so what happens in the event that an employee actually contracts the COVID-19 in the workplace?
So there are different consequences that arise for an employee who contracts the virus in the workplace compared to where he or she contracts the virus outside of the workplace. In this regard, on 23rd July 2020, again, the Minister of Employment and Labour published a revised directive for compensation of workplace-acquired COVID. This directive must be read in conjunction with the Compensation for Occupational Injuries and Diseases Act, which I'll refer to as COIDA. COIDA, as we would be aware, provides for compensation for injury or diseases that are sustained or contracted by employees in the course of their employment or for death resulting from such injuries or diseases. The directive sets out the requirements and process for submitting compensation claims to the Compensation Fund in the specific event that an employee contracts COVID-19 in the workplace. The directive provides that a workplace-acquired COVID-19 diagnosis would depend on the existing number of situations. So it contemplates certain instances where an employee could contract or is deemed to contract COVID-19 in the workplace. So one of the considerations is whether there is an inherent risk posed by a specific category of work or occupation that the employee is engaged in. So what the directive does is it makes provisions for 4 categories of risk, ranging from jobs that are deemed to be very high-risk jobs to jobs that are considered low risk. So for example, anyone who's involved in the medical services industry is deemed to be involved in a very high-risk job. And obviously, the less you interface with cases of COVID, the less exposed you are to the public, the lower the risk of the job is deemed to be. But these classifications are only guidelines to indicate the likelihood of the virus having been contracted at work. And all employees are nonetheless entitled to make a claim for compensation if they do contract the COVID virus in the workplace. You can also be deemed to have contracted the virus if you are exposed to a known source of COVID-19 at the workplace. So for example, if you have a colleague who's tested positive and you work in close contact with that colleague, that would be a deemed exposure as well. Or additionally, where an employee has gone on an approved work trip. So it's been instructed by the employer to go on a work trip to countries or areas of high risk of COVID-19, so where you have the hotspots. Where any of these situations exist, then the employee would also need to be properly diagnosed with COVID-19 according to World Health Organization standards. So there would need to be a proper medical diagnosis of the virus. And what the employee would also need to establish is that there exists a chronological sequence of events that can demonstrate the exposure at the workplace and the ultimate development of the symptoms. So there has to be a connection between those two in order to establish that you contracted it at work as opposed to outside of social engagement. Insofar as who can apply for compensation, the directive confirms that the Compensation Fund should consider all claims and then determine whether the fund is liable to pay compensation based on all of the information that I've just discussed that has been submitted to it. The Compensation Fund will only, however, pay compensation for confirmed workplace-acquired cases and where it has accepted liability. So you won't necessarily get compensation. The fund has to assess the claim and then accept liability for it. The Compensation Fund won't pay compensation for unconfirmed cases which are still being investigated. So where an employee self-isolates or self-quarantines, but it's not sure whether or not he or she actually has COVID, the employer should deal with these types of instances and absence in line with the Consolidated Health and Safety Directive, like I've just discussed. And also potentially, as Chloe said, if TERS does go forward, the illness benefits in TERS. If the fund does accept liability, then compensation for temporary total disablement due to infection with COVID will be paid from the date that the employee is diagnosed up to a maximum of 30 days. Where there are medical complications, the Compensation Commissioner has the right to review each case. If there has been any permanent disablement of an employee as a result of COVID, this will be assessed 3 months after the date of diagnosis, basically to allow the employee to improve his or her health as much as possible. And they deem that 3-month period in this regard to be appropriate. If a qualifying employee dies as a result of COVID-19 complications, the fund will cover reasonable burial expenses, and where applicable, the widow or widowers and the dependents may receive a pension of some sort as well. Again, I just want to stress that all of these considerations that I'm saying is subject to the employee having contracted COVID-19 in the workplace. In the event that an employer becomes aware that an employee has contracted COVID-19 or is suspected of having contracted the virus in the workplace, then this should be reported in accordance with the directive without delay. So there are reporting obligations on the employer. And the directive explains how reporting by an employer must be done, how an employee may claim, and what information and documents will be required to be submitted. So again, if there is a request, we can always make this directive available to participate in the webinar after we've wrapped up. Thanks, Linda.
Okay, thank you so much, Lenja. That was actually very insightful. So now we've heard about health and safety protocols that employers basically need to employ for their employees in the workplace. But are there any legal considerations that small businesses should, be thinking about if their employees are working from home? Chloe, I don't know if you'd like to respond to that.
Sure, and I think this is a very important question, Linda, because as we know, many employees have been working from home for almost 8 months now. And for many businesses, this is an entirely new concept. They haven't had employees working from home in the past, and they haven't really been able to give much consideration to it. It's just something that's been thrust upon them by these Disaster Management Act regulations, which required all employees to work from home when they could. And one thing arising from this arrangement, which we've noticed some employers don't always appreciate, is that the employer's health and safety obligations towards their employees don't necessarily stop at the office door. So just because your employees are working from home doesn't mean that there are now no health and safety considerations. And the reason I say this is because of the definition of a workplace in the Occupational Health and Safety Act, which defines a workplace as any premises where a person performs work in the course of his employment. So now we haven't had any specific cases which confirm that an employer's health and safety obligations will extend to the home or the home office. But because of this very wide definition of a workplace, it is arguable that they will. And what this then means is that the employer's obligation to provide and maintain a reasonably safe working environment may then extend actually to the home office. And this could potentially mean that even the requirements in the facilities regulations, for example, to provide your employees with a workplace that has an adequate supply of drinking water and sanitary facilities, and where their work is performed sitting and it's reasonably practicable to do so, an ergonomically sound seat. So all of these things you need to be considering. And with that in mind, when you think about it, really, if an employer wants to be sure that all of these things are in place, they should really be conducting an inspection of the employee's home office. But I mean, I think we can all appreciate that that is not very practicable for many employers. So one of the things that we've been advising our clients is that if your employees are still working from home, then you actually get them to sign a declaration form in which they say that they feel that their working environment is reasonably safe and there's no risk of harm, and that they also then indemnify the employer against any liability that may arise because they're working from home. Another consideration, Linda, is in terms of the Basic Conditions of Employment Act, employers are required to regulate the working hours of their employees with due regard to their health and safety, and also with due regard to their family responsibilities. And I think that one of the major trends that we're picking up with employees working from home is that they're tending to work longer working hours, and their home and working life are just blurring into one. So I think it's very important as an employer to actually encourage your employees to get them to set working hours for themselves, even if they're not coming into the office or into a centralized workplace, and get them to stick to that so that they still have that time at the end of the day to just switch off and have that family time. So it's just so important for managing an employee's mental health, which I'm sure we will all appreciate is just as important as managing an employee's physical health.
Okay, so I'll ask Yeleni to talk to us a bit more about mental health. But before we move on, can you confirm whether an employee's duties and responsibilities towards their employer, particularly in things like performance standards, still continue to apply even while working from home? Is that, because that's something that could clearly probably impact their mental well-being?
Yeah, so even while employees are working from home, it's very important to make them aware of the fact that their duties towards the employer continue to apply. They still need to comply with all the employer's rules and policies and procedures that may be in place. So for example, if your employees start moonlighting, because now they're working from home, no one's seeing what they're doing, and they're starting to conduct other business during working hours, and they haven't disclosed this to the employer, that's a misconduct issue that may need to have disciplinary action taken. And, you know, we will probably see a lot of issues arising around disclosing confidential information of the business, because now you're sitting at home and you've got members of your household also at your house. So all of these are disciplinary issues that may arise. So it's very important to make your employees aware that even though they're working from home, disciplinary action can still be taken against them if they breach or violate any duties or policies. And with regards to performance standards, they still need to keep up with their performance goals and their performance targets. But, you know, in this regard, because they're not maybe having that face time with their managers, employers may well need to be more proactive in taking steps to schedule regular meetings with their employees to actually check that they're on track and receiving the support that they need. I think that there's now going to be a risk where employees just try and blame their performance issues on their home circumstances. So they might be saying that, you know, I can't perform well because I don't have access to the right technology, or, you know, I don't have the right resources available for me. So these are issues that may come up, and you're going to need, as an employer, to deal with them. And one of the things that you can do is actually put in place a work from home policy, which deals with all of these issues, deals with the misconduct, the performance issues, and just clearly sets out for your employees what is expected of them, even while they're working from home.
Okay, thank you so much, Chloe. That was actually very, very helpful. So, I mean, I think we've learned that, you know, working from home has come with its own challenges from a personal and a legal perspective on both the employer and employee side. The world of work has changed overnight, and employees have had to adapt and essentially work where they sleep. So this notion of always being switched on has exacerbated the risks of burnout, anxiety, and depression. So Lenny, would you mind telling us a bit more about what these challenges mean for employers, particularly in relation to their mental well-being?
Sure, thanks, Linda. So I think this is a really prevalent topic that has been overlooked for quite a number of years, and COVID-19 has kind of made this topic much louder than it's ever been before, because we are all in our own way dealing with certain challenges, whether it be the fear of catching the virus, whether it be, you know, always being switched on and having to juggle homeschooling and being in your home environment and still trying to reach your targets. There've obviously been financial pressures. There's an economic crisis that we're all afraid of. Even if you've got a job currently, you don't know where you'll be next year. And these kind of uncertainties, you know, are fueling the fire of individuals suffering mentally. The stats before COVID-19 hit us was that 25% of our working population have been diagnosed with depression. And I'm sure that this rate would have increased exponentially over this year. South Africa has the 8th highest rate of suicide in the world, with 8,000 people committing suicide every year. When you think of stats like this, you realize that this is actually a global crisis happening at the very same time as COVID, and we can't ignore these kinds of issues. Now, as an employer, you may think that these are issues that your employee must be dealing with in their own personal time, and this doesn't affect you at all. But in fact, when an individual is suffering from mental illness, they are unable to perform at the appropriate or required speed. So for example, they may start performing badly and you decrease productivity, or they are unable to get out of bed and they struggle and they then increase absenteeism. So either way you look at it, your business operations are going to suffer from your individuals who are unable to perform properly because they are suffering from mental health. And so it becomes as much your problem as it is the individual who's suffering. Now, in terms of our law, you have a requirement to maintain the safety of your workforce, and this includes the mental well-being of your employees. As Chloe had touched on, you know, checking in and properly checking in with your employees, but not only about capacity and work, but actually, how are you doing? Are you coping? Are you overworked? If you have an individual who's suffering to perform and you then place them on a poor performance process, you're not actually dealing with the cause of the problem. And if you try and do training or guidance or help them along the way, they're not going to improve because the underlying issue is that their mental illness. And our courts have actually recently confirmed that depression must be looked at as a form of ill health. So what this means is that you are required to follow an incapacity route when dealing with somebody who is suffering from depression or anxiety. And what this means for you as an employer is that you need to look at reasonably accommodating the employee, potentially looking at reducing working hours, allowing for flexible working arrangement, looking at how you can reduce these workplace stresses that are increasing the individual's anxiety or depression. So there's actually far greater responsibility for you as an employer when dealing with your employees' mental health that I think many of us have actually been unaware of. So it's really important that if you see that someone's performing badly or you see that someone is struggling, you actually need to speak to them and find out what is the underlying cause before taking any action. Trying to create an open environment where your employees will feel comfortable to come forward and tell you or disclose that they are suffering. There's such an immense stigma around mental health. And if you try and create an environment where, you know, having depression is the same as having diabetes, it's not something you can shake off with good thoughts or have a sleep and wake up feeling better. It's something that you need proper, adequate treatment for, and something that needs to be dealt with the same way that it's dealt with physical treatment. And if you start kind of implementing these sorts of discussions with your employees, you're able to better manage it going forward. So for me, I think the biggest thing is to just start speaking about it. If you don't speak about it, you aren't able to manage it, and the effects on your business will become far greater. But I don't want to go into too much detail. If you have questions, we can, you know, discuss this on a more detailed basis. Thanks, Linda.
Okay, thank you so much for that, Yeleni. I think that was very insightful because, yeah, I think it just presented a different aspect to this conversation because we obviously as lawyers are going to focus on any legal aspects of any issue, but to have a conversation so openly about mental health, I think is definitely pertinent. I haven't yet received any questions from the Q&A. So I don't know if the attendees have any further questions to ask us. And then to the extent that they do, I will raise those with you. In the interim, there was just something that I was considering during Lenja's presentation. And that was in relation to, you know, basically employees being in a shared workspace where their chances of contracting the coronavirus are actually a bit high. So I just wanted to ask about workspaces that have, you know, employees from different companies. So you have this workspace called A, and you have employees from, you know, the company that is basically, you know, has a lease agreement with the building. And then you also outsource cleaning services from a different company. And then you also outsource a catering service from a different company. What kind of synergy or collaboration will be expected from each of those different companies, employers who have all of their employees in a shared workspace?
Thanks, Linda. Yeah, that's a great question, especially with regard to the increasing sharing of workspaces. So yeah, the Occupational Health and Safety Directive, I think it's important just to note there, it doesn't just apply to employees, right? So it's not just in relation to the employer-employee relationship. It applies to workers. And workers also includes things like third-party contractors. So you mentioned, you know, cleaners, which are generally outsourced services that might be working in a shared building. So there's definitely a cross-functionality with responsibilities. So if you're working in a sort of building that, you know, people lease certain areas, then generally the primary responsibility will fall within the landlord to manage the overall sort of health and safety regulations of the building. And that would be things about checking air quality, it would be checking workplace, it would be doing deep cleans, all of that kind of stuff. But obviously the landlord would have to work with the tenants in order to facilitate all of that. So I guess to your question is just to point out that there needs to be collaboration. The health and safety directive does apply to workers, not just to employees. So an employee's obligations don't just stop with their employees. They need to ensure that service providers who are coming into the workplace are adequately protected. And I guess, I don't know, things like hot desking and hot seats and stuff, you know, you still need to maintain the safety protocols of social distancing, but it really is a case-by-case basis. So you need to consider, and that's what I said earlier about conducting a risk assessment of the specific workplace that you're in. So that would be having considerations whether you're in a shared workspace, the amount of service providers that you have in, whether you share it, you know, you're leasing the property from a landlord, what steps are they taking? And really within a consideration of all of those factors, decide what you can do, what is best and what is reasonably practical. So you don't have to take every single step that you can possibly conceive of. What the Occupational Health and Safety Directive requires, read with the Occupational Health and Safety Act, is that employers must take steps that are reasonably practicable to secure the health and safety of their employees. So it is within reason, it is within what is possible within your resources, within your specific context, and then that will be considered. Just sorry, I don't want to monopolize most of the time, but just on another aspect of that, what the Health and Safety Directive also says is that, you know, where there are reasonable grounds for an employee to believe that he or she might be immediately exposed to the risk of infection of COVID, they can refuse to work. And really what that is then is it a balancing exercise. So there you would have to look is whether the employee's refusal to work is reasonable in the circumstances. And that would be balanced against what has the employer done in order to protect the health and safety of the employee. And if a situation like that arises where an employee does refuse to work, what the directive requires is that the employer and the employee basically sit down and try and almost mediate the situation, see if they can come to a workable solution that helps both of them. If they can't, then what the directive provides is that they actually need to contact a health and safety inspector to come in and make a determination on whether or not the circumstances of that arrangement are reasonably justifiable for the employee to refuse to work. As I've said, if the employer has implemented measures that are reasonably practicable, so you have social distancing, you make sure that the employees wash their hands, all of the requirements that I said for small employers, then, you know, arguably, unless they are vulnerable employees, so they have pre-existing health conditions over the age of 60, the employer would be able to demonstrate that they have done what they reasonably can do in order to protect the health and safety of their employees.
Okay, thank you so much for that, Lenja. That was very helpful. I'm just checking. I think we just got one question. So Bonolo has asked, for employees who choose to work at hubs, can employers still be held responsible for their infection? I think that probably links to what you spoke about earlier on and the definition of a workplace, you know, which is basically any place at which work is performed during the term of employment.
Yeah, I think just on that point as well, you know, it is, at least from a COIDA perspective, it is quite difficult. So I guess, and Chloe, please jump in as well, just from the workspace element, but I guess it would be how formal that arrangement is in a way, at least to establish, you know, workplace infection. So the benefit of COIDA is if you make COIDA contributions to the compensation fund, an employer can't be held liable in law for an employee contracting COVID. So what that means is that the employer can't be sued by the employee. The compensation fund takes over the responsibility for compensating the employee for contracting the virus. But what does tend to jump up with me there is how would you, in my mind, it would be quite difficult to establish that that was contracted during the course and the scope of workplace. I guess you could look at the, the working hours, what the employee was doing there. But for COIDA purposes, it needs to, like I said, you need to be able to establish a nexus or a link between what was happening and the eventual contraction of the virus. Chloe, I don't know if you have any comments just on the workplace scenario.
Yeah, no, I completely agree with you, Lenja. I think it may be more difficult for employees to actually show that link for purposes of the COIDA claim. But obviously it's up to them, they should notify the employer as soon as they have contracted the virus. You submit a claim and ultimately it will be up to the compensation fund to make the decision, and you would put all of the evidence before it, and it would be up to the compensation fund to actually make a determination about whether that virus was contracted in the course of employment. But definitely, I think that a shared hub would constitute a workplace. So it is possible that COIDA would apply there.
Okay, thank you so much for that, Chloe and Lenja. Bonolo is also very grateful. She said, thank you for responding to her question. So we do not have any other questions from, the attendees of this session. And to the extent that there isn't any kind of closing remarks, I would like to thank each and every one of you for your time. I think today's presentation was so insightful, and it was honestly very helpful. I mean, even with, myself working in a different department, there's so much that I took away from this, and I'm very grateful to each of you, Yeleni, Chloe, and Lenja. Thank you for your time this morning, and thank you for the informative presentation.
Thank you so much.
Thanks, everyone.
Thanks, everyone.
Right. Thanks, everyone. Cheers. Bye.
Bye.
Bye.